Any adjournment request?
May it please your lordship.
Yes.
I beg to mention listing for criminal appeal 406/2023. The
For what?
last date of posting in,
For orders.
yes,
Did you?
oblige.
Yes.
May it please your lordship. Your lordship, I beg to mention for listing of an IA in a criminal appeal.
Okay, give it to the court master.
My lord. The day after tomorrow.
Give it to the court master.
Daily list for admission. Item 1.
Yes, Mr.
May
Chakraborty.
President. Should this matrimonial appeal is against the judgment and order dated 10/7/2025 passed by the learned family court Kamrup.
Okay, heard Mr. A. Chakraborty. Learned counsel for the appellant. This appeal under section 19 of the Family Courts Act 1984 is preferred against a judgment dated 10/7/2025 passed by the Court of Learned Principal Judge, Family Court Class 1 at Kamrup Metro, Guwahati, in FC within bracket civil. Case number 244/2018. Full stop. By the judgment dated 10/7/2025. The Learned Family Court dismissed an application under section 13(1) small IA page 52 of the Hindu Marriage Act, read with section 27D Roman 1 of the Special Marriage Act, preferred by the appellant as the petitioner, for dissolution of marriage by a decree of divorce. Full stop. Issue notice. The appeal is admitted for hearing. We have gone through the grounds urged in a memo of appeal. The appeal is admitted for hearing. Issue notice for returnable on so and so. The
23rd February.
appellant takes for service of notice upon the respondent by speed post within 3 working days from today.
23rd February. Item 2.
May it please your lordship.
Oh, the records of so and so be called for.
Lordship, there is a matrimonial appeal against the judgment and order dated 9/1/2025 passed by the learned.
Section
Family
heard
Court.
Mr. S. Learned counsel for the appellant. In this criminal appeal under section 19 of the Family Courts Act 1984 is preferred against a judgment and order dated 9/1/2025 passed by the same court, in FC Civil 1283/2021. Okay. By the judgment and order so and so. The petition filed under section 10 of the Indian Divorce within bracket Amendment Act 2001, preferred by the appellant as the petitioner, praying for dissolution of a marriage by a decree of divorce. Has been rejected. We've gone through some sim. We've gone through sim. Case records admitted. Case records, issue notice, steps, respondent number, respondent, sole respondent, it post within 3 working days from now.
23rd February.
Obliged.
Item 3.
Husband filed.
Lordship.
It was allowed.
Expert.
Ex parte.
Your Lordship, we need to file an affidavit in opposition, Your Lordship.
You fine. Heard Mr. Ali, learned counsel for the appellant. You have filed Wakalat or what?
Yes, Your Lordship. We are there in the IA for
Okay.
condemnation.
And Mr. S. Paul,
Yes, Your Lordship.
learned counsel for the respondent. Full stop. This appeal under section 19 of the Family Courts Act 1984, read with section 28 of the Hindu Marriage Act 1955 is preferred against an order dated 23/7/2024 passed by the Court of the learned Principal Judge, Family Court, Nalbari. Ex parte. In matrimonial suit, case 27, capital D, bracket. Case number 2207 of 2023. Full stop. By the order dated 23/7/2024, comma. The petition, a petition preferred by the respondent as the petition under section 13(1) small within bracket small IA and small IB of the Hindu Marriage Act 1955 has been allowed ex parte, thereby resolving the marriage between the appellant and the respondent. First, we have gone through the grounds urged in the memo of appeal. The appeal is admitted for hearing. The case records of so and so be called for, issue notice, returnable on so and so. As Mr. Paul, learned counsel for the respondent has entered appearance, accepted notice, issuance of formal notice to the said respondent is dispensed with. However, comma, the learned counsel for the appellant shall furnish a copy of the memo of appeal along with the annexers to Mr. Paul within 3 working days from today.
23rd February.
Oblige, Your
Then
Lordship.
number 4,
May it please your lordship. Lordship, kindly pass over the matter for the time being.
Why?
Lordship, my senior is in another court.
Hmm. The interim prayer. Interim prayer to 9. I need to. Your petition has been rejected. So we are admitting the appeal. Who is your senior?
Mr. A.R. Karim.
Let him come. Let him come. After some time.
item number 5,
May I please your lordship? Lordship, item may be passed over for the time being. Mr. Conductor Counsel, Mr. A.R. Bhuya is on line.
Filed against us, so. Maintain is a influential, but probably good from the method.
item 6,
Please, your lordship. Lordship, we have preferred this appeal against the conviction under section 6 of the POXO Act and the
Heard Mr. S. D. Learned counsel for the accused appellant. And Mr. R. R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam. this criminal appeal under section 415 BNSS is directed against a judgment dated 10/10/2025 and an order on sentence dated 16/10/2025 passed by the Court of Learned Additional Sessions Judge Special Judge, POXO, Kamrup M, Guwahati, Trial Court in Special Court in Sessions within bracket special case number 250 of 2024, arising out of Hatigarh Police Station case number 154 of 2024, post of by the judgment and order on sentence, the accused appellant has been convicted for the offense and offenses under section 6, POXO Act 2012 and section 127 within bracket 2, BNS 2023, post of for the offense under section 6 POXO Act, the accused appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 50,000, with default stipulation, full stop, for the offense under section 127 within bracket 2 BNS 2023, he has been sentenced to undergo rigorous imprisonment for 6 months. Full stop. The sentences are ordered to run concurrently. Full stop. We have gone through the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. The case records of so-and-so we call for. Issue notice returnable on so-and-so as Mr. Kosik, Learned Additional Public Prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam, by issuance of formal notice to respondent number 1 is dispensed with. However, extra copy 3 working days. The petitioner the appellant, accused appellant shall take steps first. Service of notice upon the respondent number 2 in terms of the practice direction so-and-so. Within 3 working days from today. The Learned Additional Public Prosecutor is to obtain a report as the service of notice upon the respondent number 2 from the officer in charge at the Gaon Police Station to place the same on the returnable date.
25/2. Item 7.
Appeal against conviction, under section 147, 148, 324, 302, and 149 of IPC, my lord, passed by Learned Special Judge Bongaigaon, my lord.
Heard, Mr.
M. Rahman.
M.
My lord,
Rahman.
my lord, here in this case, my lord, senior counsel PJ Singh is there and other 3 advocates are also there. My lord, their names are not reflected in the cause list.
No, you are in this case or not?
Yes, my lord, I'm here. My name is reflected there, my lord.
That you mentioned before the history. Heard, Mr. M. Rahman.
May I please your lordship, under section 430 of the
We are
BNS.
not into that.
Yes.
You have the
the
opportunity to file. Heard, Mr. M. Rahman, Learned Counsel for the accused appellants. And Miss M. Devi
Kumari,
Learned Special Public Prosecutor,
retainer counsel, yes, public prosecutor.
Public Prosecutor for the respondent number 1, CBI, post op. This criminal appeal under section 415 to Bharatiya Nagarik Surakha Sanhita 2023 is directed against a judgment, an order dated 12/8/2025, passed by the Court of Learned Special Judge Bongaigaon Special Court in special within bracket CBI case number 06 within bracket capital B of 2012. Full stop. By the judgment and order dated so-and-so, the special court How many of you are here?
All total five, my lord.
All the five?
We are for three, my lord.
Ah. The special court has convicted five accused persons, including the three accused appellants hearing, comma, for the offences under sections 148 stroke 324 stroke 149 IPC and section 302 stroke 149 IPC. Full stop. For the offence under section 302 stroke 149 IPC, the three accused appellants have been sentenced to undergo imprisonment for life and to pay a fine of rupees 15,000 each with a default stipulation. First of all, the offence under section 148 stroke 324 to 149 IPC. They have been sentenced to undergo rigorous imprisonment for 3 years each. The sentences are ordered to run concurrently. We have gone through the grounds urging the memo of appeal. The criminal appeal is admitted for hearing. The case records of so-and-so be called for, issue notice, returnable on so-and-so, as Miss M. Kumari, learned public prosecutor. CBI has appeared and accepted notice on behalf of the respondent number 1, CBI, issuance of formal notice to respondent number 1, CBI is dispensed. However, an extra copy of the memo of appeal, along with annexure, is to be furnished to Ms. Kumari by the counsel for the appellant within 3 working days from today. The accused appellant shall take steps for service of notice. Oh, both. Sub-inspector, this his formal party, respond number 2,
Yes.
1 and 2. Yes.
25 to.
Obliged, my lord.
Okay, we'll issue notice then in the
Yes, your lordship.
Miss so-and-so, Mr. So-and-so, learned counsel for the applicant appellant. And Miss M. Kumari, learned additional, learned public prosecutor, CBI, for both the opposite parties. That's respondents. This application under section 430 BNSS is preferred by the applicant's appellants seeking suspension of execution of the sentence passed against them and for a release on bail, post of issue notice, returnable on so-and-so. As Ms. Kumari has appeared, accepted notice on behalf of both the or opposite parties as respondents, issuance of formal notice is dispensed with. The objection on behalf of the opposite parties respondents is to be filed on or before the returnable date. Therefore, suspension of sentence are to be considered after receipt of the TCR.
Item 8, 4 orders.
May I please, Lordship, in this case, we have taken steps against respondent number 2. And no report has come as yet. So for IA is also there.
What is the offense?
Offense is 376-2 Act for 14 years he has been convicted.
376
F.
2F.
Well, 14 years he has been convicted. IA is also pending.
I is pending. What about the service report?
Service that is not there. We have taken steps on long back 31/7/25. But no report has come.
Sound notification comes out. Is it possible? You are quite happy.
Lordship, this matter.
Yes.
My learned senior colleague B. Bhuya is appearing, my lord. Perhaps she might have some information or she asks us to take some time. My lord, she is coming, my lord, for the time being, my lord.
We are not facing the bail without the presence
No,
of the.
regarding service, my box.
376 2.
Maybe she has some report, my lord.
She has some report.
Maybe, my lord.
Okay,
Then I'll-
let us wait.
Yes, sir.
What is it?
Item 9.
May I please, your lordship?
Yes.
My lord, in this case, book is prepared, but I have not received one. So copy may be short, my lord.
This is POXO.
POXO, my lord.
Let us see.
POXO 6 month.
Report. Ms. Bormon, you have.
My lord. So
আৰু
without.
কিবা আহিব আছে নেকি? এইটো আহে। You have received the case papers?
No, ma'am.
No. Paper book ready?
Yes, ma'am.
Ready,
No,
madam.
I meant to mean appeal to some. PP, you have received
Yes,
paper
we have
book.
received.
So the respondent number 2 as well as the appellant, they are not getting that. Heard Mr. N. Uddin, learned counsel for the appellant. Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, state of Assam, and Miss M. Bormon, learned legal aid counsel for the respondent number 2. First off, Mr. Uddin and Miss Bormon have submitted that they have not received a copy of the, they have not, it is ready, I think you did not take.
Lordship, I have not been informed. Not aware of the.
They have not yet collected the copy of the paper book from the registry. First off. In the above view of the matter, the raise the case. This appeal after 2 weeks.
My lord, if possible, my lord,
Raise the case on so and so.
my lord, if possible,
In the
next week.
meantime, Mr. Uddin and Ms. Bormon shall collect the respective paper book from the registry.
My lord, if possible, next week, 27.
Date, Iman.
9 February. 9 to.
9th February. Ambulance.
Item number 10.
Yes.
Lordship. This is a petition for suspension of sentences and releasing him on bail.
But here.
Appeal has already been admitted.
Yeah,
1 minute.
Lordship, here service is complete, my lord.
Service complete.
Service complete, my lord.
Okay.
And perhaps
She received. Okay. We'll issue notice in the IA. Third, Mr. A. Sahad, learned counsel for the appellant. Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, state of Assam. First off. The TCA has been received. First off. Mr. Kosik has submitted that service of notice upon the respondent number 2 is complete as a report has been received from the officer in charge, Uga Mok Police Station, to that effect. So stop. A copy, a photocopy of the service report, marked as X, has been placed by Mr. Kosik. So stop. On 10/6/2025, receipt on day, huh? Post on. As none has appeared to represent the respondent number 2, we deem it proper to appoint, yes, suggest,
My lord.
let respondent number 2 be represented by some
Legal counsel.
legal counsel.
S. Nawaz, my lord. S. Nawaz.
ATY. From learned counsel, from the panel of legal aid counsel to represent the respondent number 2. Post of. Or as legal aid counsel, am I legal aid counsel?
My lord, Mr. Tiwari is also amicus.
Huh?
I think his name is also there in amicus list.
Yes, Tiwari, yes, sir. Okay, the registry to supply the necessary case papers to Mr. Tiwari. Within 2 weeks from today. The name of Mr. Tiwari, learned legal aid counsel, is to be reflected in the respondent side of the cause list. Full stop. I hired Mr. A. Sahar, learned counsel for the applicant appellant, and Mr. R. Kosik, learned additional public prosecutor for the opposite party, that's respondent number 1, State of Assam. This application under section 430, okay, 389, 430. B and S is before seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Full stop. Issue notice returnable on so and so. As Mr. Kaushik represents the opposite party as respondent number 1, State of Assam, comma, the no formal notice is necessary. First of thus, opposite party, that's respondent number 1, State of Assam, shall file his objection on or before the returnable date. First of, as Mr. A. Tiwari, learned legal aid counsel, has been allowed to represent the opposite party, that's respondent number 2, comma, Mr. Sahar, learned counsel for the applicant appellant, shall serve a copy of this application to Mr. Tiwari within 3 working days from today. First of, the learned legal aid counsel representing the opposite party, that's respondent number 2, is also shall also file objection to the instant application on or before the returnable date, if so advised.
Item number 11.
Appeal to due.
May I please the lordship? My lord, IA is filed for suspend of the sentence
Okay.
and release on the bail, my lord. And last year, my lord, the concerned advocates has collected paper book, my lord, and this appeal is ready for hearing, my lord. Last year.
Service is complete, lordship, according to the order of 11/9/2024.
1 minute. Judgment. POXO.
Lordship,
No,
not Foxus, no, 302.
302.
Yes, my lord.
Conviction.
Life imprisonment.
11.
I had to keep.
11.
Yes, sir.
11. Yeah, Sultana.
এটা একেলগে কৰি দিম।
Conviction
Objection to the.
302. Oh, I thought that it was tried by special judge POXO.
Lordship,
Okay, what was the John to be listed after 2 weeks? Paper book has been prepared. It's treated to be already complete.
Lordship,
But it is 302.
Yes,
Lordship.
We are not
No, Lord-
going to
Lord-
appoint any
Lord-
amicus.
Lordship.
Okay. Then which one you
Should
prefer?
place both together, Lordship,
Huh?
together.
Together.
I and as the paper book is ready, so she wanted to fix the matter for hearing. Then Lordship, I know if she is not
I-
placing the eye, then.
We are not
we'll
placing the
file
eye, we
objection.
are closing it.
Lordship,
Paperwork is ready.
Lordship.
Yes, my lord.
If you have a very good case, then others don't have a privacy case, we are not going to ponder over it.
Lordship.
Yes, my lord.
Yes, Miss Sultan.
Yes, my lord. I am going through the main appeal, my lord, through the paper book.
Paperwork is ready.
Yeah, next, my lord.
And what is the? How many witnesses? Only 6.
6 witnesses, Lordship.
My lord, there are 6 witnesses.
Eyewitness is there.
My lord, there is no.
Eyewitness.
There is no any eyewitness, my
No
lord.
eyewitness.
Yes, my lord.
Okay. And what is the relationship between the disease and the accused?
My lord, this is the wife of the accused, my lord.
Wife of the accused.
Informant is the stepfather of the deceased, my lord.
Stepfather.
Yes, my
Lordship,
lord.
judgment dated 24/4 in the synopsis index, Lordship, passed by additional session judge come special judge POXO.
That is why I wondered. But he is also additional session judge.
Lordship.
So he can
Lordship.
definitely pass this order.
Lordship.
My lord, in this case, PW1 he's the first prosecution witness. MO is the my lord, Dr. Palas Jyoti Datta.
Lordship is taking the matter.
No. If you are not pressing the IA, we are closing it.
Lordship, then fixing for hearing. Lord.
And
My
let us see his period of. He has been in jail since 2009 till today, 2000. Since 2.5 years.
my lord, today is possible for hearing, my lord.
Oh, madam.
So you kindly go for the IA, my lord.
Okay, we can go for the
Then we'll have to
objection
file
filed.
objection, not file, Lord.
Not filed.
There was order nothing objection on that, no.
So kindly, there may be fixed for filing the objection in IA, my lord. Then appeal.
Art. Miss B.R.S. Sultana Lanet. Legal counsel
Yes, my lord.
for the applicant appellant. And Miss A. Begum Lanet. Additional public prosecutor for the opposite party. That's respondent number 1, State of Assam. Full stop. This application under section 430B and S 2023 is preferred seeking suspension of execution of a sentence passed against the applicant appellant and for his release on bail. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal under section 415 BNSS against a judgment and order dated 24/4/2024 passed by the Court of Learned Additional Sessions Judge cum Special Judge POXO Tinsukia Trial Court in Sessions Case number 174 of 2023. Full stop. By the judgment and order dated so and so, the applicant appellant has been convicted for the offense of murder under section 302 IPC, and he has been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. Full stop. But it has been averred that the applicant appellant is in jail since 9/6/2023. Full stop. Issue notice returnable on so and so. As Ms. Begum has appeared and outlined additional public prosecutor has appeared and accepted notice on behalf of the so and so. No formal notice is necessary. Full stop. The state is to file its objection on or before the next date of listing.
25/2.
Full stop in the appeal. Okay, paperwork is ready. You have received a copy of the paper?
Yes, my lord. My lord, I have to issue notice to the respondent number two, my lord. No,
Not
no
required,
need.
not required.
Sorry.
Item number 12.
Need to some.
Made please, your lordship.
It do, put it.
I file an I.
1 minute, 1 minute.
I to for striking out. Responding number two is left. Made to review. Yes.
IA 1398.
Actually, lordship, in criminal appeal, respondent number two is inadvertently made this party.
Yes, Mr. Kosik. 302 conviction,
My lord,
sentence. Now informant was made a party. Respond number 2. Now this IA has been filed to strike out the name of respond number 2. And the state is prosecuting the
otherwise not
necessary,
mandatory,
otherwise.
not necessary.
Art, no? Art Miss H. Chakraborty, learned counsel for the applicant appellant. And Mr. R. Kosik, learned additional public prosecutor for the opposite party, press respond number 1. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal under how many applicants appellants? Single?
Appellant,
Single or more?
single.
Okay. Committing criminal appeal under section 415 BNSS to assail a judgment and order dated 14/2/2025 passed by the Court of Learned Sessions Judge Kokrajar, Trial Court, in Sessions case number T1/72/2019. Post stop. Where are your co-convicted persons? Other two? Lokman Ali, Aisa Bibi, they preferred appeal. They also preferred appeal.
Yes, preferred an appeal.
We have the numbers.
Yes, lordship.
This appeal has been preferred by only Ahmed Hussain, is it?
Ahmed Hussain is
Huh?
there, yes.
2 other persons have been convicted. Lokman Ali and Aisa
It's
Bibi.
already already released.
Huh?
And the judgment is there is no any convicted on this, on
Is
that
it
part.
so?
Committed murder in the life, whenever there is no implementing evidence. Page numbers, see, IA 134, suspension sentence, page number 65. Paragraph number 38.
But only single person was convicted.
Single person, is this already, there is no any convictions on
See
that?
the second page of the judgment then. Okay. Need to properly require equitably call issue. Equitably call interlegal and preferred no against us by the judgment and order creative so the use applicant appellant has been convicted for the offense of murder under section 302 IPC, and he has been sentenced to undergo rigorous imprisonment for life and pay a fine of rupees 10,000, which is equal stipulation. Full stop. Where this interlocutory application is preferred by the applicant appellant to strike out the name of the opposite party number 2, who has been arraigned as respondent number 2 in the accompanying criminal appeal on the ground that as on the ground that the prosecution is represented by the state poster and implement of the informant or implement of the opposite party, the respondent number 2, who was the informant, comma, is not necessary. Poster Mr. Kaushik, Learning Additional Public Prosecutor for the opposite party, the respondent number 2 has submitted that since state is prosecuting. Since the state had prosecuted. Comma, the informant would not be a necessary party. Full stop. In view of the above submissions made by the learned counsel for the parties, comma, the instant interlocutory application stands allowed. Thereby allowing the prayer of the applicant appellant for striking out the name of the respondent number 2 in the accompanying criminal appeal. Post of registry, huh? Oh. Okay. The registry to carry out the necessary correction. Post of
Lordship,
LCR, I see anything.
Lordship, is there suspension or sentence, Lordship?
No, we'll file objection.
Please, yeah, in the appeal. Heard Ms. S. Chakraborty, learned counsel for the appellant, and Mr. R. R. Kaushik, learned additional public prosecutor for the respondent state. Post of. Para in deference to the order dated 21/11/2025, comma, the appellant preferred an interlocutory application, IA criminal number 139/2025, and the said application has been allowed today. To stop. Para. As the TCR has been received, comma, the office to prepare the paper book, lays the appeal after 4 weeks for a report as regards preparation of the paper book. Poster. T74. And Ms. S. Chakraborty, learned counsel for the applicant appellant, and Mr. R. R. Kaushik, learned additional public prosecutor for the opposite party, that's respondent state. Poster. Mr. Kaushik has sought for and is granted 4 weeks time to file an objection on behalf of the state. Poster. Lays the case after 4 weeks.
Much obliged.
Timing matter. Item number 4.
Yes, Mr. Karim, your associates for time.
Lordship,
We are only admitting it,
Lordship,
nothing that.
nothing. It
Are Mr. A.R. Karim, learned counsel for the appellant. Post up. This appeal under section 28 of the Hindu Marriage Act 1955, read with section 19 within bracket 1 of the Family Courts Act 1984, is preferred against a judgment dated 1/8/2024,
Lordship,
passed by the Court of learned Principal Judge Family Court Dhuri, Family Court. In FCTSD case number 09/2023, page 27. By the judgment dated so and so, comma, past ex parte, comma, a petition preferred by the respondent hearing as the petition under section 13 within bracket 1 of the Hindu Marriage Act 1955, seeking resolution of the marriage by decree of divorce has been allowed. Has been dismissed. Full stop. We have gone through the grounds urged in the memo of appeal. The appeal is admitted for hearing. The case records of so and so will call for issue notice returnable on so and so. The appellant shall take steps for service of notice.
Service already complete, Your Lordship, in IA order, Your Lordship, last order. There is an IA, last order, Your Lordship.
No, take steps. Appellant shall take steps for service of notice upon the respondent by speed post within 3 working days.
LCM may kindly call.
Already called.
25th February, 25 to.
Obligation.
Item 5.
Yes.
Lord, I'm sorry, my lord was on lag, my lord. My lord, decree, my lord, has been allowed wherein, my lord, the,
We are admitting the bill.
my lord, my lord.
Hired Mr. A.R. Mia, learned counsel for the appellant. This appeal under section 19 of the Family Courts Act is deferred against a judgment dated 11/11/2025
My lord.
passed by the Court of Learned Principal Judge Family Court -1 Kamrup Metro Guwahati in FC civil case number 825 of 2018,
My lord.
page 110, full stop. By the case, FC civil case number 825 of 2018 was registered pursuant to an application preferred
Section 7N and B of Family Courts Act, page 111.
preferred by the respondent herein as the petition
My lord, my lord.
under section 7 small a and 7 small b of the Family Courts Act 1984, read with section 34 of the Specific Relief Act 1963, praying for declaration of decree of divorce as null and void, full stop, by the judgment and order dated 11/11/2025, the Learned Family Court. Allowed the same, but declaring that allowed the petition, holding that the decree of divorce dated 17/6/2016 issued by the Office of the Muslim Marriage, page 118, para 16, stroke divorce registration and the Sodor Kazi Guwahati, Kamrup Metro, Assam, as null and void and non-operative,
My lord,
right?
my lord.
Okay, we have gone through the grounds urged in the memo of appeal. The appeal is admitted for hearing. The case records of B so and so be called for. Issue notice returnable on so and so. The appellant shall take steps for service of notice upon the respondent by speed post within 3 working days from today.
27 to.
Till then, the operation of the.
Null and void.
My lord, the only, my lord, what they have done, my lord, the Sadar.
Stay separately.
Mild. Oblige.
Nobody can force you.
Mild. But my lord, I am apprehending that she may come and enter in my house, my lord, that's.
Take protection.
Oblige, my lord.
Don't enter into remarriage,
My lord, my lord.
third or second or I don't know.
Nowadays, it is risky also, there is a law also, my lord. Oblige, my lord.
Item number 8 for orders.
Yes, some service. Yes. Offense is
376 2 Act for 14 months.
Lordship, copy is here.
this year, prepare book ready.
Paperwork I have received.
Paper book ready, my lord. We have filed our objection.
I had Mr. D. Talukdar, learned counsel for the
Objection copy as a source.
Sure, copy with this one.
accused the appellant and Ms. B. Vuyan, learned senior counsel, and additional public prosecutor represented by Ms. M. Das, R. Das, learned counsel for the respondent state. Post up, Ms. Vuyan has placed a report received from the officer in charge,
Dillai Police Station.
Dillai Police Station, report dated 18/1/2026, within bracket, marked and kept as document text. Reporting that the notice has been duly served upon the respondent number 2. Post stop. Yes, 376.
It was served on
376.
informants.com.
2 Act.
man. It will be done as per the.
In view of the report, in view of the report, service of notice upon the respondent number 2 is treated as complete. So is it a case to be represented by any amicus? Or
Yeah, the view of the other court number 2 is that if they come up and approach it, they don't know the means, then the.
otherwise you will proceed, not
Yes,
not
my
a
lord.
POXO case,
My lord.
not a POXO,
Not a POXO,
minor.
minor. Victim is minor.
What is the notification?
তো নাসে নাকি আমারটা?
But he was prosecuted also under section.
No POXO, no POXO Act. Case of 2012,
A, B,
maybe prior to POXO Act, it was registered.
মিসপ্লেস হয়েছে। কি ব্ল্যাক কালার তো ছিল নাকি আরো কোনটা আছে? ব্রাউন কালার।
Okay, এখন রাখি দেবো। Okay, this is regarding AP. Now, what about the IA?
Next day, today so far IAs are not prepared.
File, state objection file.
Of
Okay.
the file,
Lordship, copies have done them, but I have not checked the records.
Huh?
whether it is
Let me
there in
see.
the record or not.
What is status to some?
Objection is there.
Hmm.
Heard Mr. D. Talukdar, learned counsel for the
Hmm.
applicant appellant, and Ms. B. Vuyan, learned additional public prosecutor. Learned senior counsel and additional public prosecutor. Tested by Ms. So-and-so, learned counsel for the opposite party, that's respondent state.
27 তোমার এখন নাই, no?
The state has filed its objection, post of as sought for and agreed to by the learned counsel for the parties. Lays the case, yes.
On 27 January,
Not not this month,
not this.
next month.
PB is ready, PB copies, PB is served.
Read your date.
18 February.
Objection hearing.
Must. No, here.
On.
On.
If the exercise is same for considering the IA on the appeal, then
Yes.
we may proceed
Fine.
for the
Lots.
appeal also.
Lots.
Fine.
We have not applied our mind.
Lots.
Lordship. 19/1.
It will go to 6. It will.
For hearing, item number 13,
Yes.
This is jail appeal, Lordship, and two appealants before your Lordship.
We should Hali.
Yes.
Or in the,
Bijul Hali and
where is
Lordship,
judgment?
judgment, Lordship, is at page 36.
36. We should Hali, Molin Hali.
Molin Dhali. Brother and sisters,
Both are
brothers-
convicted.
both are convicted under section 302-34. Wife of Vishnu Dhali died, and thereafter brother of the deceased lodged an FIR. On that basis, the investigation was conducted, and after trial, these both were convicted. And mother was also an accused. So during trial, she died. So against her, case is awaited. That your Lordship will say.
And
Page
direct evidence or circumstantial?
circumstantial evidence.
Circumstantial. How many witnesses were?
Seven
Seven.
witnesses.
Hmm?
Seven
Seven
witnesses examined.
7 witnesses. Okay.
And those circumstances your Lordship will get at
No, we'll go over it
Lots.
serially.
Lordship.
We cannot pick up from middle and understand everything,
Lordship.
right?
Lordship.
We'll proceed from the FIR only.
FIR your Lordship will get at page 4.
Yes, Mr. Jaka, you are for whom? Huh? Informant?
Yes, madam.
Hey, doctor, pencil, it's normal pencil. হবো হয়ে যাবো এটা কেন হয়ে যাবে হয়ে যাবো
Page 4 is the FIR Lordship. It was lodged on 30/12/2010. Page 5 is the relevant portion of the FIR
1 minute, Govinda Mallik,
Lordship. Brother of the deceased.
brother, elder or
That elder brother.
elder?
Lordship.
Deceased. So Bishu Dhali. So in the FIR only Bishu Dhali was named.
No, 3 persons named. Or
Okay.
present to appellants along with mother. Page 5 your Lordship will get middle portion.
Yes, please read.
Humble submission is that my younger sister, Srimati Kanan Malik, died on 29/12/2010, Wednesday, in her husband's house as a result of torture inflicted on her. I have come to know from a special source that she was completely fine during the daytime. I therefore pray to you to take necessary action expeditiously after investigating the matter and oblige. So this case was registered under section 302-34, Lordship. And charges, your Lordship will find page 6. Charges were framed under section 304B-34 and section 302-34 against all the 3 accused persons, Lordship. And that Rosmimoni Dahal died in the year 2016. So against her, case abated.
What is it?
Page 6.
Judgment is dated
Judgment is
22. So during trial.
during trial. And Lordship, the present appellants are acquitted from the charges under section 304B-34. Now, PW1, your Lordship will find at page 9. Is the informant. I know accused persons. They are Rajmoni Dahali, she died. Bishu
What is the
Dahal,
exact name of the disease that died?
uh,
Rasmoni Dhali, Rasmoni Dhali. This is the consistent name.
Rasmoni Dahali.
Rasmoni. So here it is Rasmani, in the charge, Rasmani.
Lordship. Lordship.
Okay.
And Molin Dhali. Accused Rasmani Dhali is not present in the dock. Some 4 years ago, we got married to one of our sister, Kanon, with accused Bishu Dhali. After marriage, the accused persons tortured my sister physically and mentally. My sister many times asked me to take her back, as her husband used to beat her badly. One day, my sister informed me over phone that she was physically tortured and requested me to take her back. One day, I went to the house of my another sister in the same village of the accused. Then one brother-in-law of accused Vishud Ali informed me that my sister died. Then I
His
went.
brother-in-law is witness?
No, Lordship, that I do not find the evidence, Lordship. Then I went to the house of accused Vishud Ali and saw my sister lying dead on the floor. I saw injuries on my sister's neck and leg. I have not found any family members of the accused in their house at that time. Then I informed the matter to police and lodged the FIR. Police came there and prepared sketch map. I put my signature in the Ejahar. Exhibit 1 is the Ejahar and Exhibit 1 is my signature. Exhibit 2 is the inquest report and Exhibit 2.1 is my signature in the inquest. I have not seen who killed my daughter. So here ought to have been sister. Who killed my daughter, but I believe that my family members of her in-laws house has killed my sister. Cross by defense. Before this incident, my deceased sister gave birth a child in Ananta Memorial Nursing Home at Tezpur, and that child died after 2-3 days. My father and mother committed suicide by jumping in the river Dhansri. My house is situated at a distance from my sister's house, which takes 3 hours time if travel by bus. I came to the house of the accused from the house of my sister Sikha, wife of Bhaven, at around 7 p.m. And on that night itself, I lodged the affair. So here, Lordship may kindly note that time, Lordship, 7 p.m. Because they said, Lordship, that the deceased died at the intervening night. But actually, in fact, Lordship, she died prior to 7 p.m., Lordship, in the evening. And at that point of time, accused was in market. That is his 313 statement, Lordship. So therefore, I am pointing out to the time, Lordship. I came to the house of the accused from the house of my sister Sikha, wife of Bhavennath, around 7 p.m. And on that night itself, I lodged the FIR. I have not lodged the FIR on the following day. Near the house of my deceased sister or accused, there were houses of Bhojan, Biswas, Basu, Robin, Maheshwari. I went to my sister's house even after birth of her child. My sister reported me about physical and mental torture committed by accused Vishud Ali and other family members, but I have not informed anybody. I have no visiting terms with the neighboring houses of the accused. It is not a fact that for the depressing owed to the health of newly born child, my sister committed suicide by hanging herself on bamboo bushes. FIR was written by one Niranjan Mondal and it was lodged on 30/12/2010, but the occurrence took place on 29/12/2010. I have not stated before the IO that my sister informed me about the torture committed upon her by her in-laws and about the fact that she requested me to take her back from the house of accused. It is not a fact that I have not stated before the IO that when I went to the house of my sister Sikha, the brother-in-law of accused came and reported me about the death of my deceased sister. I have not stated before the IO about the injuries sustained by my sister. It is not a fact that I have not stated before the IO or in the FIR that I saw the dead body in the house of accused. After the marriage, the relationship between my sister and her husband was cordial. At the time of birth of son of my sister, accused paid 18,000 for medical expenses of my sister, and I also helped my sister for her treatment in the nursing home. That time relation was cordial. After 1 month of the said delivery, the present incident took place. The mother of the accused is more than 80 years of age. The mother of the accused, Rasmani Dhali, is an old woman, and now she is in bedridden condition. It is not a fact that allegations made is not true, and a false case has been instituted against the accused. Now, PW2, she is the sister of the deceased.
Justin. Yes.
Page 12, sister of the deceased, she was declared hostile by the prosecution. I know the accused persons standing in the dock. One of them is Vishud Ali, who is my brother-in-law, and another one is Malin Dhali. She is the elder sister of Vishud Ali. I also know the absentee accused Rajmani Dhali. Again Rajmani, who is the mother of Vishud Ali. I know the informant Govinda Mallik, who is my younger brother. Deceased Kanan Mallik was my younger sister. The occurrence took place about 4 years back as on today. My sister Kanan Mallik was given in marriage with accused Vishud Ali before about 1 year from the date of incident. After the marriage, she delivered a daughter in the house of accused Vishu, and the occurrence took place about 3 days from the date of delivery of girl child. On the date of occurrence, one Subhas Dhali, the brother-in-law of Vishu Dhali, informed us that my sister Kanan Mallik was seriously ailing, and she was in the house of Vishu Dhali. After receiving the said information, I, along with my husband and brother-in-law, went to the house of Vishu Dhali and found my sister Kanan Mallik while lying dead on the ground in the living room of Vishu Dhali and Kanan. When we came to the house of Vishud Ali, we did not find any of the inhabitants there. So far, I know the conjugal life of my sister with the accused Vishud Ali was peaceful, and there was no dispute among them. Declared hostile caused by prosecution. It is not a fact that I stated before the police that since after marriage, my sister Kanan Mallik was subjected to torture and cruelty by her husband, Vishud Ali, and mother-in-law and his elder brother. It is also not a fact that I stated before the police that after birth of her child, my sister was subjected to torture and cruelty by her husband, mother-in-law, and sister-in-law. And on 29/12/2010, at 8 p.m., the accused persons caused death of my sister Kanan Mallik by committing physical and mental torture on her, and thereafter her husband and sister fled away from the house. It is not a fact that today I have concealed the actual fact and deposed falsely in connection with the case. By defense, the house of informant Govinda Mallik, who is my younger brother, is at Dolgaon number 2, Borjar under Dorong district. My marriage was solemnized before the marriage of my deceased sister. I myself brought the proposal of accused.
Where is the IO?
IO is Lordship PW7. That actual IO died subsequently he deposed before the court, Lordship. PW page 23.
Okay, come to page 26.
Lordship.
This part has been put to the IO.
Lordship.
So what will be the consequence?
If it corroborates with other evidence, that it can be taken into consideration.
No, this part. Hostile, after declared hostile.
Lordship.
PW2 was declared hostile.
Lordship.
This part of 161 statement
Lordship.
was put to the prosecution by the prosecution in cross examination.
Lordship.
Then in the same manner, like defense puts the contradiction, it has been put to the IO. And he admits that this witness in her previous statement stated like this. So what will be the consequence?
Here, Lordship, in my humble submission, that statement ought to have been exhibited, but that has not been exhibited in the present case, Lordship.
So what will the evidentiary value?
Now, in the present case, that cannot be considered because it was not proved in accordance with law, Lordship.
Okay. Okay. Come to page 13, by defense, cross by defense.
Lordship. The house of informant Govinda Mollik, who is my younger brother, is at Dolgaon number 2, Borjar under Dorong district. My marriage was solemnized before the marriage of my deceased sister. I myself brought the proposal of accused person for marriage of my deceased sister. The house of Subhas Thali, Bojan Biswas, Basu Biswas, Dimbu Mondal, and Banka Biswas are situated near the house of accused persons. When I arrived at the place of occurrence, I found gatherings of many people there. It is not a fact that I did not state before the police that I found the dead body of my deceased sister in her living room with the accused Bishu Dali. Now, PW3, page 14. His neighbor. Neighbor. I know the accused persons standing in the dock. One of them is Bishu Dali and another one is Molin Dali. She is the elder sister of Bishu Dali. I also know the absentee accused Rasmani Dali, who is the mother of Bishu Dali. I know the informant Govinda Mollik. The deceased Kanan Mollik was the wife of Bishu Dali. Before 2 years from the date of incident, the marriage between Bishu Dali and Kanan Mollik was solemnized, and after marriage, Kanan Dali resided in the house of accused Bishu Dali and led her conjugal life there with the accused. Apart from Bishu Dali and Kanan Dali, the mother Rasmani Dali and elder sister Molin Dali of accused Bishu Dali also resided in the matrimonial house of deceased Kanan Malik. The occurrence took place at evening time on the date of occurrence. At the time of occurrence, I was present in my own house. Then one Robin Mondal, one of the relative of accused persons, came to my house and informed me that Kanan Malik expired. I did not go to the house of accused persons on that day. The following day, while I was sleeping in my courtyard, police came to the house of accused persons and called on me there. After arriving in the house of accused persons, I saw the dead body of Kanan Malik lying there in the courtyard. At that time, the mother of the accused, Rasmani Dhali, was present at home, while I did not see Bishu Dhali and Molin Dhali there. Police asked me in connection with the case. Cross. The accused persons are my neighbor. The house of accused persons are situated at hearing distance from my house, but on the date of occurrence, I was watching TV and hence I could not hear any hue and cry raised in their house. I have not heard at any point of time that accused persons committed torture in pursuance of their demand for dowry. I have not stated before the IO that I was informed about the incident by one Robin Mondal. I saw the dead body of Kanan Malik lying in the courtyard on inner side of their campus. I have heard about the incident at evening time of the date of occurrence. I went to the spot at 9:30 a.m. on the following day. I saw 30-35 persons gathering in the house of accused person when I went there. At that time, I saw Bhaven Mondal, Robin Mondal, and some others there, but I cannot remember the names of other persons. At that time, I saw the elder sister of deceased Kanan there. PW 4, page 16. She is sister of deceased.
Hmm?
Sinka Mondal, elder sister of deceased.
Maybe Sikha.
Sikha. Sikha Mondal.
Hmm.
Accused Bishud Ali is my brother-in-law, husband of my younger sister. Accused Molin is Bishu's elder sister. This is Kanand Ali was my younger sister. The incident took place some 7 years ago. About 1 year prior to Kanan's death, she had got married to accused Bishu. On the day of occurrence, Kanan was at her husband's house. The incident occurred around 7 p.m. I was at my house then. Bishu's brother-in-law, husband of his younger sister, Subhas, came to my house and said that my sister Kanan had fallen ill and he asked us to visit her. On receiving the news, my husband and I went to the house of the accused and found my younger sister dead in the house. No one was present in the house. I saw red mark on her neck and injury in her legs. Many people came. My younger brother informed the police station of the incident. The police came. My younger sister had a good relationship with her husband after her marriage. My younger sister gave birth to a baby, but the baby died in the hospital 3 days after its birth. The relationship between them deteriorated since then. The police held inquest on the dead body and I put my signature on the inquest report. Exhibit 2 is the inquest report and Exhibit 2 is my signature.
This PW4
Lordship.
and PW2 and the disease, they were sisters.
Sisters.
This PW2 and PW4's matrimonial houses are in the same village. Because this brother-in-law of the disease or Subhas, he was going everywhere.
Lordship.
To the house of PW2 as well as to the house of PW4. Subhas was not examined.
Yes, it shows, Lordship, that residence village is same.
Huh?
Baridua,
Baridua.
Lordship. PW 2 and 4.
Baridua, PW4, PW2. Okay, same village.
Same village.
And this diseased
Diseased
village is, let us see the FIR.
FIR is of Uluwani. Uluwani police station, under same police station.
Huh?
Under same police station.
1.5 mile difference, Lordship.
No. Village. Boridua, Faridua. Okay, Faridua maybe. This neighbor is from Faridua also, PW3. So village is Faridua.
Residence of husband's residence is
This PW3 is also Faridua and he is the neighbor.
He is the neighbor.
So Faridua.
Residence.
Village is Faridua.
Yes, accused persons reside at Patoli Ati. Page 27, 313 statement your lordship will get. They reside at Patoli Ati. Page 20.
This Binoy Bormon, he says he is the neighbor.
Lordship.
And he says, I reside at Varidua.
Lordship.
PW2 and PW4, both Faridua.
Lordship.
Then this accused now, page 27, he says what?
I reside at Patoli Ati.
Page
27. Top
Which line?
portion, Lordship, after those names, before question number 1, Lordship.
Patoli.
Like to pull out it, no?
Let us see the IO first. I was just for information.
Vamos secular, PW1 2.
Any Varidua? Okay. Haridwar.
Oh, yeah, resident.
Haridwar. All are from Haridwar. How he can, I don't know. PW5 is also from Haridwar.
Oh, সেইটো দেখিছো।
Okay. Continue with PW4. Cross.
Line to
In charge sheet, Lordship, page 66, your Lordship will get that village Patoliati. Here also,
It is not
page 66.
page 66.
Yes, 66 and 67.
Patolia T.
Police station is same, village is probably different.
Lordship, in the sketch map, Lordship, sketch map of 71, Lordship, the road is known as Bharidwa Kesa Road. The PO is Pataliati.
Down below it is road Patoliati, Karamari side.
Karamari side, but the road, Lordship, belongs to it is Bharidwa. Same, Lordship.
Because this PW5 also says he is from Haridwar.
Bharidwa.
PW3, he also says Haridwar.
Haridwar.
PW2 and PW4, they also say Haridwar. So, and all say that accused reside in our same village.
Lordship.
Meaning thereby it should be Haridwar.
Bharidwa, because it is Bharidwa Kesa Road. In this sketch map, it is there, Lordship. The middle portion it is middle.
In the FIR also it is Pauliati. Patoliati or Pauliati, something like that. FIR.
Yes, in FIR also it is there.
Pauliati. Maybe neighbor, very short distance.
So maybe that.
ঠিক আছে Pauliati neighbor. ইয়াতো বাৰু ইনফৰ্মিং টু ইউৰ বেলেগৰ দলগাঁও এইটো বেলেগ বাৰু গৰম কিন্তু 2, 3, 4, 5 চবেই কৈছে Haridwar বুলি কৈছে আকৌ Pauliati কয় আৰু FIRটো Pauliati লিখিছে
In page 60
কি কয় পোষ্টমৰ্টেমতো Pataliati maybe ওচৰা-ওচৰি নেকি এইটো Pataliati ভিলেজ Pataliati ৰিলিজ কেইটা লিখা নাই নহয় ৰোডটো লিখিছে
In page 68, your Lordship will get the details of witnesses. Here also 2 village name is there, Lordship. One Baridwa and one Patoliati.
Right, there is 2 villages, maybe neighboring villages.
Maybe neighboring, Lordship.
But PW2 and 4, they are saying we are neighbors.
Lordship.
We are from Haridwar. And others are saying.
Probably their houses are adjacent to that border area. That may be lost.
Patoliati, Bharidwar, village 2. Arun Mondal, village 2. Nishikanta Bormon, side. Shikram Mondal, Haridwar. No, 71. CO2. Tuna is Tens dwelling house. Tens dwelling house to Kuntu. Zia Bonai 1, 2, 3, 4 version. 1, 2, 3, 4 কৰিছে কি কৰিছে এইটো ঘৰ যেন পাইছো মাজৰটো ইয়ো দিছে Pune is better than own residence of Koridua Bill Pass. Amlagaon Patrolling T. Telephone Tower. Ematuli. Maybe near to each other. Perhaps. Because doctor also says Pataliyati. Autopsy doctor. Others are saying Koridua. Okay. Page PW4.
Page 16, last line also. No one was present in the house. I saw red mark on her neck and injury in her legs. Many people came. My younger brother informed the police station of the incident. The police came. My younger sister had a good relationship with her husband after her marriage. My younger sister gave birth to a baby, but the baby died in the hospital 3 days after its birth. The relationship between them deteriorated since then. The police held inquest on the dead body and I put my signature on the inquest report. Exhibit 2 is the inquest report and Exhibit 2 is my signature. Cross. Informant Govinda Malik is my younger brother. My paternal home is at Dolgaon in the district of Dorong. The distance from my house to that of the accused is about 1.5 miles. I do not remember the date of the incident. Both of my parents committed suicide. At the time of the incident, my younger brother had come to my house. After Subhas had given us the information, first my younger brother went to the house of the accused. He went around 7 p.m. Later, my husband and I went there. After reaching the house of the accused, I saw my younger brother there. No member of the family of the accused was present there. My brother informed the police station of the incident. My younger sister died 3 months after the death of her child. I learned that my sister gave birth.
Somebody says 3 days, somebody says 3 months.
Lordship.
Oh, really? Yes.
My younger sister died 3 months after the death of her child.
Somebody said 3 days.
After someone
Who
said
said?
that
Baby died, Lordship.
Huh?
She birth the baby. She died.
no, in PW2 says Lordship occurrence took place after 3 days from the delivery of girl child. Page 12.
PW2, another sister.
Lordship.
She says 3 days.
3 days.
3 days. Now another sister says 3 months.
Lordship.
Lordship will have to go to the Assamese, Lordship, because sometimes there is.
Yeah, that is why I called it. Find out. No, this is a fact which is to be remembered.
No.
Right. This is a fact which cannot be
Ignored. Lordship.
Yes.
I learned that my sister gave birth to a baby girl. My younger brother Govinda Malik and my husband took my sister to the hospital for her delivery. I have not heard that we should. I have
Okay,
not.
Mr. Ahmed
Lordship.
will write for some time.
Page 17, Lordship. My younger sister died 3 months after the death of her child. I learned that my sister gave birth to a baby girl. My younger brother Govinda Malik and my husband took my sister to the hospital for her delivery. I have not heard that Bishud Ali spent rupees 18,000 for Kanan's treatment. After the death of Kanan's child, a quarrel used to break out between Kanan and her husband, and thus the relationship between them deteriorated. After the death of Kanan's child, my younger brother visited my house on the day of Kanan's death only. He had not come to my house in intervening period, Subhas, Dimbu, Bhushan, Rupsan, Binoy Bormon, and Bhajan lived with their families in the vicinity of the accused person's house. Basu Biswas, his mother, and his 3 unmarried sisters live very close to the house of the accused. I saw red mark on my sister's neck and leg. Bishud Ali and his 2 brothers share the same campus with their families. There is courtyard in the middle of the house. We did not find the members of the accused family when we went to the house of the accused. The police questioned me on the following day of the incident. It is not a fact that I did not state before the police that around 7 p.m. on the night of the incident, Bishu's brother-in-law had come to my house and said that my younger sister Kanan had fallen ill, that she had asked us to visit her, that then my husband and I had gone to the house of the accused and found my sister dead, and that I had seen red mark on her neck and injury on her leg. We informed our village headman Nilakanto Bormon about the incident and we immediately came to our house. Then my younger brother and my husband again went to the house of the accused along with the village headman. At that time, I was at my house. I do not know the reason of my sister's death. It is not a fact that my sister committed suicide. It is not a fact that I have deposed falsely. PW5, Robin Mondal. I know the 2 accused persons present in the dock today. I also know informant Govinda Malik. I knew deceased Kanan Dali. Kanan Dali was Bishu Dali's wife and informant's younger sister. The incident occurred about 8-9 years ago. Around 10 a.m. one day, I heard that the police had come to the house of the accused. Then I also went to the house of the accused and saw Kanan's dead body lying in the courtyard. A lot of people gathered there. I did not see the 2 accused persons at their house. The deceased was my sister-in-law, younger sister of my wife. I am not on visiting terms with the accused. I do not know if Kanan had already disagreement with Bisud Ali. I know nothing about the incident. Now, PW6, page 21. He was the doctor who conducted post-mortem lordship. On 31/12/2010, I was posted at Bhugeshwari Fukanani Civil Hospital, Nagaon, as MNHO. And on that day, I did post-mortem examination on the dead body of one Kanan Malik, female, age 24 years of village, Patoli Ati, PS Uluoni District, Nagaon, with reference to Uluoni PS case number 95 of 2010, dated so-and-so, under section 30234 IPC, which was escorted and identified by constable number so-and-so, Arun Mondal. On examination, I found the following. A dead body of a female 24 years, eyes and mouth open, rigor mortis present. A ligature mark is seen in the neck between chin and thyroid cartilage. It is continuous. Now here I am pausing for a moment, Lordship. He deposed that it is continuous. But if your Lordship peruse the post-mortem report says it is non-continuous. And because of this deposition, Lordship, trial court held that it is, Lordship, homicidal in nature. That post-mortem report, your Lordship will find page 62. I have checked it with original, Lordship. It is correct, Lordship, in the paper book. Page 62. Relevant portion I am referring to page 63, Lordship. Serial number 1. Condition of subject so-and-so. Dead body of female so-and-so. Rigor mortis present. A ligature mark is seen in the neck between chin and thyroid cartilage. It is non-continuous. In original also your Lordship will get.
In opinion, Lordship, they have given something. In the opinion section, Lordship, in PM only, Lordship, that is due to asphyxia following strangulation.
This deposition is clearly contradictory.
Clearly contradictory.
That part, ligature mark,
Lordship.
non-continuous, continuous.
Yes.
Yes.
After dissection found hyoid bone fracture, abrasion found in right leg of size 3 cm into 1 cm, one number, and so healthy. Details already. So now, in my opinion, the cause of death was due to asphyxia following strangulation. In case of vigorous force applied on neck, then hyoid bone is fractured. The death is homicidal in nature. So here he opined that the death is homicidal in nature. In cross-examination, first line, Lordship may kindly see, in my report, I have not specifically mentioned whether the death was homicidal or suicidal. So that is not there in the report.
Oh. It is not there.
It is not there. He admitted that part. I have not specifically mentioned whether death was homicidal or suicidal. Page 65 of the paper book.
Yes.
The time of death may be within 24 hours. So she was examined on Lordship 31/12/2010. And incident occurred on 29th. I have not made any remark about the tongue. Ligature mark found in the neck is complete, that is continuous. In case of strangulation, there is chance of broken down of hyoid bones. In case of falling in hard substance, such type of abrasion may cause in the leg. Fracture of hyoid bone may also cause in case of hanging. So what I find, Lordship, his deposition is neither here nor there.
Yes.
And his finding regarding that, Lordship, continuous and that homicidal, that is not in the record, Lordship. So that part, in my humble submission, also cannot be taken into consideration. Now, PW7 is the IO, Lordship, page 23. On last 10/10/2011, I was posted, just before going to PW7, I am just taking your Lordship to the inquest report also. Inquest report is also silent regarding whether it is continuous or non-continuous, page 58. In fact, there is a specific column for that. Page 59, down below your Lordship will get column 10C. So that also prosecution did not mention anything on this Lordship. Because it is burden of the prosecution, they have to prove their case, Lordship, beyond reasonable doubt. Now, page 23, Lordship, PW7, IO. On last 10/10/2011, I was posted at Uluoni PS as officer in charge. On that day, I received the case diary of Uluoni PS case number so-and-so under section so-and-so from my previous officer in charge, Sri Dhiren Burman. Accused Bisud Ali appeared at the police station after getting anticipatory bail from the Honorable Guwahati High Court. I interrogated the accused and allowed him to go on bail. Thereafter, I was transferred from the said PS and handed over the case diary to Sri Khogen Borua, who was at that time second officer and OC in charge of the PS. As per case diary, Khogen Borua has submitted the charge sheet. Exhibit 4 is the charge sheet. Exhibit 4.1 is the signature of Khogen Borua, which I know. Crossed by defense. I did not record the confessional statement of the accused person. Page 25. He was further examined, Lordship, re-examined. Earlier, I deposed in this case as one of the IO. Prior to me, SI Dhiren Burman investigated the case who already expired. I know his handwriting. On receipt of an FIR on 30/12/2010, the then OC Dhirendra Burman registered the case, Uloni PS case number so and himself initiated the investigation of the case. In Exhibit 1, the FIR, Exhibit 1-2 is the signature of OC Dhiren Burman. In course of investigation, Dhirendra Burman visited the place of occurrence, took steps for conducting inquest over the dead body by Circle Officer Novojyoti Oza and sent the dead body for postmortem examination. He also drew the sketch map of the place of occurrence. Exhibit 5 is the sketch map and Exhibit 5.1 is the signature of Dhirendra Burman, which I knew. He arrested the accused Rasmani Dhali and recorded the statement of the witnesses. After me, Second Officer Khogen Borua collected the postmortem report and submitted charge sheet in the case. Khogen Borua already expired. Dhirendra Burman also recorded the statement of the witnesses. Maheshwari Mandal, PW2. He stated before the IO that since after marriage, my sister Kanan Malik was subjected to cruelty by her husband Bishu Dali, mother-in-law and her elder brother. After birth of her child, my sister was subjected to torture and cruelty by her husband, my mother-in-law and sister-in-law. And on 29/12/2010 at 10 p.m. by accused persons caused death of my sister Kanan Malik by committing physical and mental torture on her, and thereafter her husband and sister fled away from the house, crossed by defense. I was serving in Uluoni PS for about 1.5 years. I know the surrounding village of Uluoni PS. The place of occurrence is Patoliati village. The distance between Patoliati and Uluoni police station is about 4 kilometers. As per FIR, the date of occurrence is 29/10/2012 and FIR was lodged on 30/10/2012 at about 10 a.m. Prior to lodging of FIR, no GD entry was made. PW1 Govinda Malik did not state before me that when I went to the house of my sister Sikha, the brother-in-law of accused came and reported me about the death of my deceased sister. PW1 did not state before me that I saw the dead body in the house of the accused. As per the sketch map, Bhojen Dali, Hema Dhali, Subhash Dhali, Dimbu Mandal, and Banka Biswas are the neighbors of the place of occurrence, but they were not examined by the IO. These are the evidences, Lordship, against the accused persons. Now, before going to do that 313 statement, Lordship, I'm just taking your Lordship to the circumstances which are relied on by the trial court. Now, Lordship may kindly see page 51, paragraph 27. What are those circumstances? May I read, Lordship? Thus, the following facts and circumstances have been proved beyond reasonable doubt, which make the chain of circumstances complete. The victim was married to Bishu Dhali. The victim resided in the same house along with both the accused and their deceased mother. The victim died within 2 years of her marriage with the accused Bishu Dhali. So probably this part will not come because, Lordship, this is these two appellants are convicted under section 302, Lordship.
Which one?
That serial number 3, the victim died within 2 years of her marriage with the accused Bishu Dhali. Because they were residing, that is there in serial number 2. The dead body of the victim was found inside the room where the victim and her husband accused Bishu Dhali used to stay. The victim died due to strangulation. The force applied while strangulating her was so vigorous that her hyoid bone got broken. The accused Bishu Dhali could not offer any plausible explanation as to how his wife, the victim, died. So regarding this, Lordship, I will take your Lordship to 313, Lordship, and also submit that whether the 106 Lordship can be fastened when, Lordship, that prosecution failed to prove the foundational facts, Lordship. Because prosecution has to first prove that accused was present when the incident took place. Only then, Lordship, that burden will shift to the accused. Because here they are saying, Lordship, when they went to the house of the accused, they found no one present in the house. It is not a case that prior to that accused was present. Accused Molin Dhali, also being a member of the same family, could not offer any plausible explanation regarding death of the victim. So this similar submission will be there, Lordship. Both the accused absconded from their house immediately after the occurrence. So immediately after the occurrence, they fled away. That is not there in the record. They were not present, it is there. And merely they were absconding, that cannot be taken as a sole ground to convict them, Lordship. I will submit one judgment of Honorable Apex Court regarding this. The accused Bishud Ali, although took the plea that he was not in the market at the time of occurrence, could not prove that that fact, making his plea of alibi false. So here my submission is, Lordship, that his statement was not plea of alibi. That was the explanation given to the question put to him, Lordship. That cannot be treated as plea of alibi, Lordship. So for that, I will take your Lordship to 313, Lordship. Similarly, Lordship, that serial number 11. Similarly, accused Molin Dhali also though took the plea that she was in the house of some other person, she could not prove the fact, and as such making her plea of alibi false. And both Bishud Ali and Molin Dhali took the false plea that the victim committed suicide by hanging, whereas she died due to strangulation. So it is also not proof fact, Lordship, that 12. Now, Lordships may kindly turn to page 27. Peter starts from here, Lordship, and I am relying on that paragraph, question number 5, that your Lordship will get at page 28.
5, 9,
Yes,
10,
10,
12,
Lordship.
right?
The correct, Lordship.
And Molin Dhali,
The
3,
yes.
5,
Yes. Those,
6.
yeah, those are similar to
8.
question number 5, so I am placing that 5 itself, Lordship. So may I read that question, Lordship?
We have read.
PW2, Lordship.
Yes.
PW2 Maheshwari Mondal alias Maharani Mondal.
No, you can skip that. We have read.
Lordship. So
Huh?
last line I am pointing out that, and did not find any inmate of your house. What do you have to say on this piece of evidence? So regarding this, he have given his explanation that I was absent in the house, I was in the market. So it is not a case that prosecution says that I was present when the incident took place, and then I said that I was in another place. Then it will be plea of alibi, Lordship. And here it is only an explanation. It is not a plea of alibi.
Yes.
These are the evidences, Lordship. So I am relying on some citations, Lordship. May I place those citations?
Limit it. How
Limit-
many?
Only 4, Lordship. Lordship, may I kindly say 2013-12 SCC. (406). Sujit Biswas. First, Lordship, that Lordship, may I kindly say paragraph 13. This is regarding suspicion that I am not reading. The Lordships are aware that suspicion cannot take place the place of proof. Lordship. That regarding that 13. Then your Lordship, may I kindly say paragraph 15. That Sharad Birdichan, it is relied, Lordship, regarding circumstantial evidence. And then, your Lordship, I am relying on paragraph 17 and 18. Regarding circumstantial evidence, that how it has to be proved that And paragraph 22 and 23, Lordship, regarding abscondence. In paragraph 22, one Honorable Apex Court earlier judgment is referred. And in 23, may I read, Lordship? Thus, in a case of this nature, the mere abscondence of an accused does not lead to a firm conclusion of his guilty mind. An innocent man may also abscond in order to evade arrest. As in light of such a situation, such an action may or may be part of the natural conduct of the accused. Abscondence is in fact relevant evidence, but its evidentiary value depends upon the surrounding circumstances, and hence the same must only be taken as a minor item in evidence of sustaining conviction. So here, if they had, if the prosecution had proved that at the time of occurrence they were present, subsequently they fled away, then it can be taken into consideration. Then I am relying on, Lordship, that 2011 SCC, Lordship, 754. Paragraph 31, Lordship, that regarding abscondence. May I read it?
Yes.
Both the courts below have considered the circumstance of abscondence of the appellant as a circumstance on the basis of which an adverse inference could be drawn against him. It is a settled legal proposition that in case a person is absconding after commission of the offense of which he may not even be the author, such a circumstance alone may not be enough to draw an adverse inference against him, as it would go against the doctrine of innocence. It is quite possible that he may be running away merely on being suspected out of fear of police arrest and harassment. So, Supreme Court, thus, in view of the law referred to herein above, mere abscondence of the appellant cannot be taken as a circumstance which gives rise to draw an adverse inference against him. Now, Lordship, 2019-13 SCC. Here, Lordship, may I kindly see the facts of this case also. Paragraph 2 and 4, Lordship, may I kindly see facts.
Four.
2 and 4, Lordship, regarding facts of the case, Lordship. Because ultimately, paragraph 9, 19, and 20, Lordship. For section 106 of Evidence Act.
9.
19 and 20. 9 is regarding that section 106.
Nineteen and
20, Lordship. Regarding the 313, because in 313, it was not said that after committing that offense, they fled away. It is said that the questions was put to them that you were not present. And for that, they have given their explanation that we were at market. So absconders specifically were not put to them, Lordship. And paragraph 19 says, Lordship, when the prosecution first proves their case, then that burden will shift to the accused, Lordship. So prosecution first has to prove that the appellant and the deceased were together present at the house, Lordship, at the time of incident. So they failed merely because he is the husband and another one is a sister-in-law of the deceased. They cannot be convicted, Lordship. And the last one is, Lordship, that 1992 2 SCC 153. Paragraph 9 regarding motive, Lordship, that in circumstantial evidence, motive has to be proved, Lordship. Paragraph 9. In the present case also, the prosecution failed to prove the motive because, Lordship, that torture, demand of dowry, that for that he is already acquitted by the trial court. And against that, Lordship, no appeal is filed by the state or by the informant. And further, one more submission, Lordship, that regarding 34, although it is convicted under section 34, there is no material or findings in the impugned judgment regarding section 34. What was the common, how they have, that a common object was there, that finding is not there.
yes.
Lordship, first of all, Lordship, I'll go the medical Lordship. PW6 Lordship. The difference, Lordship, the continuous and non-continuous Lordship. For that, Lordship, that they have deposed PM is of 2000 date of Lordship deposition, Lordship. It is of 5/2/11. A PM report, Lordship. And Lordship, PW6 has deposed after 8 years, Lordship. So there may be some little discrepancy in that case, Lordship. The date is, Lordship, 8/8/2018, Lordship.
So if he says that continuous,
Lordship.
then the next opinion is homicidal is perhaps drawn from that.
But one thing is there, Lordship, strangulation is there, Lordship. That is due to asphyxia, but strangulation.
That is an opinion.
That is in the PM also it is there, Lordship, that due to strangulation that and Lordship PW4. She have seen the marks of in her neck, Lordship. PW4 Lordship. Page number 16, Lordship. No one was present in the house. I saw red mark on her neck and injury in her leg.
Legs.
That is proven the medical, Lordship. There was that, Lordship. And the Lordship, the other thing, Lordship, no one was present in the house, Lordship. The husband have taken that, not alibi, but he was not present, he was in the market. But Lordship, hearing such an incident, Lordship, he will immediately rush to his house and he will inform the police, Lordship. But there is nothing like that, Lordship, nor he have declined he have declined to give adduce any evidence, Lordship. In that regards, Lordship, that he was in the market, he have heard from somebody. And in that point, he have no explanation, Lordship.
Where is the presence of the husband?
Lordship, he
Yes, it is a fact.
that he was present in the
That the mother-in-law of the deceased,
the
sister-in-law of the deceased, and husband
Lordship,
used to reside in the same
house,
right?
Lordship.
And at least there is not even a last seen theory also.
But he reside in the same
reside, yes.
the same, the husband,
Reside is one.
Lordship,
Secondly, they were in company of each other
Lordship,
prior to the incident. That is not there,
Lordship,
right? And at the time, he was not in the house. He was not found in the house. Neither the other appellant.
Lordship,
And one that Subhas,
brother,
or a brother-in-law,
brother-in-law,
who is also a neighbor.
also a neighbor,
Who informed PW 1, 2, and 4.
4,
He was not a witness,
not a, that is there,
right?
Lordship,
So he perhaps was the one
main,
who saw or witnessed the
the
dead body.
incident, Lordship,
So he was not examined.
he was not examined,
Hmm?
Lordship,
Then by the time this PW 1, 2, and 4,
Lordship,
they went to the PO. Already there was a gathering.
Lordship,
This PW 3, he took the plea. He was watching TV.
and he didn't.
He did not hear.
Lordship,
And these PW 1 or 2 or 4, they were, or that somebody was PW 5 or 6. He was the husband of one,
Lordship, PW 6,
Robin or Probin, whatever.
Lordship,
That he said that they were not in visiting terms.
Lordship,
So how they can depose that there was torture, something cruelty meted out, that somebody said the date was after 3 days, somebody said after 3 months, somebody said after the date of the baby, everything deteriorated, relationship deteriorated. Prior to that, it was cordial. It was cordial,
Lordship,
right? And somebody said that for 3 months, they deteriorated. What is the exact? Nobody says something. That
PW2 said it after 3 days of the
3
incident.
days, and people,
That
another
stays
sister, her
hostel.
sister says 3 months.
But rest of them said 3 months.
3 months. And
Lordship.
people, one, what does he say? Yes, he admitted, page 10. I have not
Lordship.
stated before the IO that my sister informed about the torture committed upon her by her in-laws and about the
Lordship.
fact that she requested me to take her back to from the house of the accused.
Lordship,
So the allegation, when the same witness admits in the cross-examination, it is not required, the previous statement is not required to be marked and put to the IO. He
Lordship.
admitted himself.
he admitted, Lordship,
Right.
he admitted.
And then where he said that deteriorated.
Mm. Before this incident, my deceased sister gave birth in my
He never visited. Right.
Lordship,
He never visited the house.
PW.
I have no visiting terms with the neighboring houses. Okay. He did not say. He said after 1 month.
Lordship,
Which one is true? Page 10, last 2 lines.
after 1 month of the said delivery, the present incident took place.
One sister said 3 days. One sister says 1 month, or the brother. And one sister says 3 months. Right.
Lordship,
That date. And he did not say anything about deteriorating a condition relationship. 2 sisters said nobody visited. nobody had any visiting terms, though they resided in the same village. Then so many neighbors were there.
Lordship.
Nobody was examined except PW3. He said, I was watching TV. I did not hear. And he says also cordial.
Lordship.
He says that I have not heard at any point of time that the accused persons committed torture in pursuance of their demand for dowry.
That is gone.
Right.
Lordship. But the dead body was found inside the house, but Lordship, the
In the
sister
courtyard.
courtyard. The
It is also not sure where it is found. And
Morin,
if it is in a courtyard,
Lordship.
this trial court has applied 106 on the basis of Trimur Maruti Kirkan.
Lordship.
It has
No
to be
access.
established that during the night it was the only the husband or anybody else who was in with the deceased. And this happened in the evening hours.
Lordship.
And courtyard, not inside the house. Body was found in the courtyard or inner side of the campus. Nobody said where it is body is found. If the higher body is fractured, does it lead to the only conclusion that that lady died by strangulation or by suicide?
There is an injury mark in the leg also, Lordship. Leg is also there is leg
The
and
leg, he said,
Molin Dhali also didn't give any explanation regarding that, Lordship. She was in the house, but she declined that she was present. The sister-in-law,
simply said that
we were not present.
no, because she said
Question number. We were not present. We fled away, being afraid.
that can be a valid explanation. Somebody stays, somebody flees.
Lordship.
But where is that prosecution is standing on its own leg?
I went in her. Lordship.
So many, about 10, 12 neighbors were
Present.
mentioned. Nobody was examined except PW3. Others are 1, 2,
3,
4 and 5. They are relatives, but still they were not neighbors.
5 is neighbor, Lordship.
Not neighbors. And nobody had visiting terms. 1, 2, 4 and 5. Looks like evidence is sketchy. 106 may not be applicable.
It is not clear that the husband, Lordship, the time is also not there, that he was simply said that I was in the market. But at
No,
what,
no, don't go to his explanation. First, you stand on your own leg.
Lordship, because there is no evidence on record that they
The
went.
doctor is maybe, but he was supposed to depose on the basis of the postmortem examination report.
Lordship.
He made a departure, significant departure,
That is better.
continuous or not
Non-continuous.
continuous. That makes a whole lot of difference.
But in the opinion on
Opinion, he said homicidal,
Lordship.
but before the court, but in the report it was not there. Asphyxia by strangulation.
Following by strangulation. So strangulation part is there, Lordship.
A strangulation part is there. Where is the evidence to support it?
But there,
This may happen. Higher bond may leads only to the conclusion that it was strangulation.
And injury in the leg part is also there, Lordship.
Huh?
Injury in the leg is also there. Because after hanging, Lordship, she will not fall down, Lordship. By herself.
We cannot.
The
use light
injury
to
is
our
there, Lordship.
imagination.
No, Lordship. As per the report, Lordship, injury is there in the leg.
I have seen.
Last line of that
It
doctor.
is, in case of falling in hard substances, such type of abrasion may cause in the leg.
Lordship.
And next line, he says, Lordship, that that Lordship's query that hyoid bone may also cause in case of hanging. That he clarified.
And two factors could be that both her parents committed suicide. Secondly,
Baby.
death of baby. These two factors, maybe yes, it could happen that she died by hanging. We are not giving flight to our imagination, but still, she died by hanging. Could have suicide.
Lordship.
This, they brought it down,
Lordship.
escaped. This could also happen.
Because the doctor,
But we are
Lordship,
not into that. Prosecution case.
Lordship, medical, Lordship, in case of strangulation, there is a chance of broken down of thyroid bone.
Chance,
The-
not thyroid. There cannot be thyroid bone.
Lord, sorry, hyoid. Sorry, Lordship, I'm sorry. In case of falling in, immediately he changes so that in the case of falling in a hard substance, then in case of falling in a hard substance, Lordship, she will have injury in other parts also. But only there is fracture and injury in her leg.
But why he has made a departure?
That is Lordship.
Because it is not a case of memory loss.
Lordship.
For other witnesses, it could be memory loss.
Lordship.
Right?
Medical.
But for him, he has to refer, he has exhibited the PM report.
Detail already. the same column.
Non-continuous indicates what? Indicates suicide by
Suicide.
hanging,
And in
not
the,
strangulation.
and in
That by rope, I
That
think
is-
it will be continuous.
Lordship. In the post
And
PM,
what
we have
is
done.
this, in suicide, what is that which is prominently? He did not depose anything about tongue or something like that. Protruded tongue, eyes, this one, that one.
In suicide, it is there.
Something like esophagus.
Lordship.
Okay, we'll come back at 2.
Lordship. Lordship, may I read PW one, Lordship?
Hmm.
Middle portion, Lordship. Page number 9, Lordship. 9th line. Because Lordship, PW one, PW two, and PW three, 4, they went immediately to the occurrence, Lordship, after they got the information, Lordship. But the PW five, Lordship, he went on the next day. And PW six also, Lordship. Page 6, 5, Lordship, 5 and 3, I think. 3. So,
Here,
Lordship, they have said about a courtyard. But
1 minute,
otherwise,
1 minute.
Lordship,
Here Moody says,
Lordship,
Moody's jurisprudence,
Lordship,
hanging,
Lordship,
ligature mark, oblique, non-continuous, placed high up in the neck,
Lordship,
between the chin and the larynx.
Lordship,
Right.
Lordship,
Now, page 21. A ligature mark is seen in the neck between chin and thyroid cartilage.
Lordship. It is,
And in case of strangulation, it should be non-continuous, right?
Lordship,
In case of hanging, he says continuous, but it should be non-continuous.
Lordship,
Next, strangulation. Ligature mark horizontal or transverse continuous around the leg, around the neck, low down in the neck, below the thyroid, here above the thyroid.
Lordship. So in
Cartilage.
between the sin and the thyroid.
The base of the groove furrow being soft and reddish. Then
After dissection, found thyroid bone fracture.
Then fracture. Where is that? In case of strangulation, a hyoid bone fracture.
Fracture.
Larynx, trachea fracture. Hyoid is fractured,
Fracture.
right? Where is larynx? Nothing. Nothing is mentioned, right? Trachea,
62 PM.
pharynx. In case of hanging, fracture of larynx and trachea are very rare and may be found that too in judicial hangings. So this is neither here nor there.
Lordship. Larynx and trachea are congested.
In case of strangulation, there is chance of breaking down of hyoid bone.
Lordship, in the post PM report, Lordship, larynx and trachea congested, Lordship, in page number 63, PM report. And right lung congested, Lordship.
And he said fracture of hyoid bone may also cause in case of hanging.
Lordship,
So both is possible.
Lordship.
Okay. Within the chin and the leg.
Is that one?
Both one of them, convolution. After was a had one, it's too high. Oh, yeah. It's.
Somebody have. Because strangulation is there now, strangulation is there. But. Like, lipo injury ki this one.
I was sketches, man. Ignoring my. Usually not present. Yes, so. ওরিটাছে কারণ মানে আমার 3 সেন্টিমিটার যায় 1 সেন্টিমিটার
Ligature mark is there. Finger of the
not definite. Yes.
Lordship, regarding seen her in the courtyard, Lordship, that is PW1, Lordship. From the page number 9, 9th line. Then I went to the house of the accused Vishnu Dhali and saw my sister lying on the floor. But he have not mentioned whether it is courtyard or the house, but it is in the floor. Then Lordship, PW2, though she is hostile, Lordship, but you also in the page number 12, Lordship, it is from the last 4th line, Lordship. After receiving the said information, I, along with my husband and brother-in-law, went to the house of Vishnu Dali and found my sister Kanon Malik while lying dead on the ground in the living room of Vishnu Dali and Kanon. And Lordship, PW4. She also stated, Lordship, in page number 16, Lordship, last line, Lordship, and found my sister dead in the house. Only PW3, Lordship, courtyard, that is, they went on the next day, Lordship. And PW5. And all these witnesses say that there was nobody in the house, Lordship.
They cannot be immediately.
Lordship. And Lordship.
They are not immediately because this Subhas.
Lordship.
He informed them.
He informed.
He informed them, and PW4 said that first PW1 went to that
PW1
place.
Lordship.
Then
PW
she and her husband
Lordship.
went there.
Lordship. But in the night itself, Lordship. Then, but this PW5 and Lordship PW3, they went next day, Lordship. PW5 went around 10:30 a.m. At 10 a.m. And Lordship PW3 after arriving in the courtyard, police came and called him.
Possibility of possibility
লগালগ ইনফর্ম করতে জিটি এন্ট্রিও করান
never even the past. Never put possibility. The police is going to be. The ring seat. The ring is no over the surface. Give it time. This is a our relationship for giving. Physical form. We are very quickly. Total piece of the fire and leave. Well, the case of the potom to global level, the people are for that. Generally, if you are from you, you have to move on with me. You to face it and put over channel. It doesn't know the different with everything is explanation given. Automatic hit for the other one is city. Yes.
Lordship, as regard the injury part also, Lordship, that is also corroborated with the medical, that is their neck injury and leg injury. And Lordship, the thing is that the medical officer, Lordship, he could have only, in his opinion, Lordship, suggestion, Lordship, that it is due to asphyxia. But he, asphyxia, Lordship. But he have said that it is forwarded with strangulation, Lordship. Because there is in larynx, there is congestion is there, Lordship.
I think there is not in the opinion that it was homicide in the PM report, but that he has added it.
That is he added, Lordship.
And that is that part he has added. Antemortem in nature.
Antemortem in nature.
Asphyxia following strangulation.
Lordship, in somewhere I have, Lordship, in already described in column, in the PM report, Lordship, page number 64, Lordship. Already described, last line, in column 1, 3, 4, it is antemortem in nature. In PM, Lordship, it is there, Lordship. It is not only simply asphyxia, Lordship. So, Lordship, I think circumstantial chain is completed, Lordship, because the injury part is also there, Lordship, as PW 1, 2, 3 have 4 have stated, Lordship. And Lordship, it was found in the house that he would ought to have explained, Lordship, that why he went to market without.
Why he went to the market?
Only I went there market. I was not present. That much only for his wife, Lordship.
No, if.
And if strangulation is done by
Prosecution has
someone.
proved that he was very much present in the house. Then if he takes the plea of alibi, then he has to prove it as a fact. Right? So the standard is not there. But here it is not a case that prosecution has proved that he was very much there, present. So whether 106 will come in these circumstances, see that trial court has brought in Trimukh Marti Kirkan in paragraph 30.
And Lordship, the plea that in the judgment it is taken, it is, Lordship, it is the fact that both the accused absconded from their house immediately after the occurrence. They were not there, Lordship. And he could not give any possible answer to how his wife died, Lordship. Simply.
Okay. Yes, Mr. Dekam.
My lord, I am also sailing with the same submission, basically. But apart from that, my lord, one more important thing is that who had informed the informant and the other witnesses. That is the person, the Subhas, who is the brother-in-law of the accused, my lord. So there are possibilities that Subhas was informed by the accused, and no one was present at the house. That if we go by that PW,
Possibilities are myriad.
my lord, definitely. Suppose this
We can
person,
allow
both the accused were on work, one is on market. But where is the mother, my lord?
Our imagination, then possibilities, we can find out 10 or at least 10 options right now.
My lord,
Possibilities.
my lord, but where is their mother? The mother was also absent in the house.
Mother was present.
No. Mother was not present immediately when they have reached. Day after that, mother was present.
So if you say that mother was not present, sister-in-law was not present, and husband was not present.
Yes. So it's quite shocking. So no one was.
Two options. Either they fled away from the scene, or they were not at all present.
So who has brought it down the body? Who has brought it down the body?
If two possibilities are there,
My lord.
which one is to choose?
My lord. But
you know,
definitely the accused person has brought in down the body. If it is even if it is suicidal murder.
That will be 201.
Maybe
202.
But no one was present at the home.
Then,
and
if no one is present in the home,
and if your lordship have a look at the inquest report, that inquest says at page 58.
it is silent whether it is inside the room or court.
Dead body found lying in south direction at Bishudali residence, husband of the deceased. So, at page 60, limbs, right leg injury mark noticed, left leg injury mark noticed.
59.
Page 60, my lord.
No, dead body found lying in.
Oh yes, it is
south,
page 15.
North direction at Bisuvali residence. It is vague.
My lord,
where it is found.
My lord, at page 60, it is apparent from the evidences of the PWs also, and from this inquest also,
He is very concerned.
that there was injury mark in both legs. The medical report says, so it was strangulation, asphyxia followed by strangulation. That cannot be. The person who has informed the informant and the other witness about the incident, it is not, he is not the relative of the informant. He is the relative of the accused persons. He is the brother-in-law of the accused.
All these witnesses are relative of the deceased.
My lord, it's not direct relative.
Sister of the disease is not direct relative.
My lord, yes,
Two sisters of the disease are not direct relatives.
no, they are direct relatives. No, my lord, I'm saying, I'm submitting that the person who has informed that Subhas, he is the brother-in-law of the accused. He is not the brother-in-law of the informant or the brother-in-law of the deceased person. And PW1 also says that, yes, there was physical and mental torture committed by the accused and his family members.
Otherwise, whatever they have stated,
PW1 says that,
whatever they have stated,
yes,
otherwise,
but
though
then-
we cannot take note of it,
My lord.
whatever they have stated it for the first time before the court. Nothing was stated before the IO. Whatever they have stated
my lord,
before the court,
yes,
they have stated it for the first time, all this.
yes,
They never stated anything about the place of incident, knowledge, information about the incident, right? Where it was lying, body was found lying, right? What are the injuries they saw?
my lord, they have stated it.
Mr.
Yes.
Decca,
It was not once before one.
Decca,
Okay, my
Mr.
lord.
Decca, at least for purpose of for satisfaction, we can see what are the things transpired. So whatever they have stated, whatever,
My lord.
I say whatever, right? They never stated in their 161 statement that so somebody informed us, then I went there, I visited this PW1, I visited my sister's house there, I was informed by one brother-in-law, then I went there, I saw the body lying, right?
My lord, their sister died, so they might be in a position.
Between at 10 a.m., they come to the court and they 10:30 or 11 or 12, they give their testimony. Everything happened in between. I'll not say much.
But accused also couldn't nullify that evidence, my lord.
No, same thing, both sides. I not say much.
The mental torture and physical torture what has been stated by the PW1 or the other PWs, that was not for dowry. That was they have not stated that that was for dowry,
Okay.
my lord.
Project. Heard Mr. AML Leonard Amicus. Amicus query for that. Accused appellants Ms. A. Burgum, Leonard Regional Public Prosecutor for the respondent number 1, Common State, and Mr. B.M. Dekar, Leonard Counsel. You are engaged counsel.
Yes, my lord.
Leonard Counsel for the respondent number 2. Arguments complete. Is complete. Are complete. Complete. Judgment is reserved.
Outline.
Much obliged, my lord.
Epistols of the
Item number 14.
Yes.
May it please, my lords.
Yes.
I'm appointed amicus in this matter, my lord.
You are amicus.
Amicus in this matter. The POXO case, my lord.
Okay.
Section 6.
Wait.
Yes, man, in this particular case
Yes.
itself, man. Thank you. All started from this case. man.
Heard Mr. Sandillo, A. Sandillo, Leonard Amicus Curie for the appellant and Mr. R. Kaushik, Leonard Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. Oh, this is the famous Deepak Nayak case.
Yes.
Yes.
In reference to the judgment dated 23/6/2023. Order. Rendered in this appeal, comma, notice was directed to be served upon the respond number 3, comma, by order dated 25/7/2023, comma, to the investigating officer concerned or the officer in charge of Khoang Police Station in relation to Khoang PS case number 76/2020 under section 376 AB, IPC, read with section 4, POCSO Act, informing the respond number 3 regarding the pendency of the present appeal. Full stop. Para. In compliance, comma, notice meant for service among the respond number 3 was issued and sent to the officer in charge Khoang Police Station by speed post on 14/9/2023. Full stop. As per office note dated 24/11/2023, comma, report as regards service was not received from the officer in charge Khoang Police Station till that date. Full stop. Para. Thereafter, no report as regards service or notice is available. Full stop. Upon the respond number 3 is available in the case record. Full stop. Mr. Kaushik, learned additional public prosecutor, shall obtain a report from the officer in charge Khoang Police Station as regards service or notice upon the respond number 3. Full stop. And shall place the same on the next date of listing. Lays the case on February
18/2. Item number 15.
Date
18.
Yes, Prabharani Bosumutari.
It's an open start case, well.
Open and start for acquittal.
No, for conviction. At least we got 1 out of 100. PW2, whether his testimony is believable.
Oh. Okay, let us have a first look. Where is the FIR otherwise?
The file your lordship will find at page
Phase 4.
4, man. It was lodged by
Page 4, Janata Bosumutari.
Donata Bosumatari. Donata Bosumatari.
Huh? Janata.
Donata Bosumatari, man.
Huh.
He happens to PW1.
My mother. It is offense under 302 or what?
Yes, ma'am.
Yes,
Okay, my mother.
302.
Janaki Bosumutari.
Janaki Bosu, this is.
My mother was.
The accused person intercepted her at Port Parasit.
My mother died on the spot. Okay. So, accused a lady.
She's a lady, man.
Okay.
Both are ladies.
Both are ladies. Okay, respond PW2.
PW1 is the
Informant.
informant.
Okay.
And he has come to know, my lord,
I came no from village. On the date of the when I was prepping,
He was informed by co-villager, my lord, Pradeep Khaklari.
Pradeep Khaklari. My mother has been assaulted by accused. Pradeep Khaklari is,
No, he
He was not a victim.
no. Assaulted by
Then-
accused by means of a sharp cutting or having, I arrived at a place for the dead body lying on the roadside. Also noticed several cut injuries on her leg, submitted.
Later on, he says, my lord, one thing, my lord. I
Huh.
was told by Dibakar Bosumatari, that is eyewitness. And on that, while he was returning,
After crossing. Hmm? So Dibakar Bosumare is star witness.
no, yes.
And no-
Yes, Sars witness actually.
she called him, but he played away. Out of fear.
Out of
Nature,
Yes, sir.
Priya Mohan Rabha,
Period 4, man.
February 4.
Yes, ma'am.
What the incident? Out of villager carried, went along with him. Okay, I did not go near a dead body. Able to say.
There was cross-examination was not good, my lord, actually.
Huh?
There was no cross-examination at all, my lord.
So the alleged assault from a distance of 80 meters.
Only suggestions were given. How it is originated, that nothing has been only the
related. In fact, accused is related to him.
According to my some hostile witness, when the son of the deceased was having affair with the accused man, that is the bone of content.
Huh? Who had affair?
The son of the deceased was having an affair with the accused man. And
Who is respondent number 3?
PW3,
Husband of the deceased.
the husband
Huh.
of the
Okay, husband.
husband.
Oh, he had allegedly affair.
No, man, the deceased, my lord. The son of the deceased.
Son of the
The deceased had a affair with the accused man. Accused man. He's a married woman.
My mother is injured. He was in my residence. Pradeep. Whether the accused appeared before a police station?
Yes.
He surrendered.
Standard
Okay,
of-
now.
Not a doubt, but she made a statement that Dow was lying in the residence of our father. So and it was recovered according to it was recovered.
Recorded my statement. Both are relative, accused and a deceased.
Yes.
Yes.
So cross-examination is to the on the point that it was a Dibakar Basuntari.
Yes.
Who committed the crime? Some suggestion
Yes,
to PW4.
PW4. But he has not asked PW2.
PW2 also.
The Dibakar is PW2.
Huh?
You should have cross-examined PW2 on that point, whether you are the person who has PW5 is Sankarawa, the Gabura.
Gabura?
Gabura. He has informed me GD83 was there. FI was filed later.
Forefinger was severe.
Severe, man. And his neck has been severely assaulted, man.
No, many injuries.
Actually, because of injuries in their neck, he expired.
But
Instantaneous
otherwise, many injuries.
injuries are there, my lord. But this fatal injury is at the neck.
Index finger.
Your lordship says the PW7, my
Proximal
lord.
palm.
That injury number 3, my lord.
Separate lower mandible. Soft wound on left side of the neck. Injury number 3.
Yes, ma'am. Neck with dissection of the vertebral column at the level of 6 and 7. Cervical vertebra, dissection of the trachea and part of larynx. So all soft tissues on the left side. It's quite deep. Man. Another inside wounds, my lord. There is stab wound in the left shoulder.
Chopped wound inside
Yes.
wounds. Vertebra. Instantaneous. Six to 12 hours.
Who is PW8? PW8 is, she was a resident of that locality, my lord. She was declared hostile. But if your lordship sees the,
My related daughter-in-law.
yes,
This is not my relative. Or are the informants.
these are co-villagers you want to see. But in the cross-examination by prosecution, my lord, one part that has come, my lord. So she has denied it, my lord, that your lordship will find. That is the motive, my lord. Down below, number 4, number 3, it is not a fact. I have stated before police, Jonathan Basumatari was unmarried. And he developed secret love affair with the accused. Over this, Janki used to quarrel with the accused. And this fact was known to both the families and neighbors. Over such quarrel, the accused is suspected to have killed Janki on the cold bath. That was statement before policeman.
But cross by defense,
Because she was declared hostile.
cross by defense he denied.
Denied. However, in cross-examination, she also denied that about the love affair. He was a hearsay with you. Other witness, there's PW Ulendo Vatasaki, 9 mile. They are hearsay witness. And PW 10 is the inquest witness.
P13 says that I did not surrender.
Yes, my lord. She's taken a host, another point, LEB, man. Last portion.
I was cooking in my house and busy with my studies of my children.
But no evidence has been laid.
Not involved. Hmm. Two 313, why? Two 313 statement, two sets.
One on fourth and one on 30. There might be some order.
One was 30. One was recorded 4/3/2020, man. One was recorded, another was recorded on 30/3/2022. That is after 2 years, man.
This PW2, he is from the same village,
Same village.
right? And his story that he could be there because I went to my paddy field on a bicycle carrying manner after applying the manner in my paddy field while I was returning from my paddy field, riding on my bicycle on the road near Bhokatpara Muga farm, I saw Janaki. Any sketch map?
Yes, yes, guess what? I read them.
No.
Asa? Guess what? I exhibited.
Page 101.
On the.
Village road.
Oh, is the place of man.
Hmm?
Okay.
Ko.
Oh.
Ko. Okay, place of occurrence. Ko. That hit one. The figure is lying. Ko. Piece of silk farm. Located Bhokatpara. Ko. 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 Go. Go. Panchayat. Ko. Mohila Committee. Cho. America Ambika Bosumotari. Cho. Janaki Bosumotari. Jo. So PW2's testimony stands, not demolished.
He is a son's witness, man.
Not chance, he is from same village.
Same village, I understand.
And his presence in the wee hours, morning hours, and his explanation that he was to his paddy field after giving manure, he was returning to his house.
Yes.
Obviously by the road.
Yes.
So his presence is not that
Doubtful.
doubtful, because he was not present somewhere else.
Yes.
From Gopalpur. He is in Gopalpur.
Yes.
And he did not question anything.
But there was no cross resemblance at all, man.
And his subsequent conduct, reporting to another person, then everybody went there. He also went there again. Solar witness can be the basis of.
That is a subtle law, my lord. Provided he is reliable.
Reliable and his presence at the place of occurrence.
Yes.
He is not doubtful.
Because his credibility has not been.
He is from some from 10 kilometer distance, and he was there in the morning.
He is not a he's a co-villager.
Co-villager. And he knew both of them.
Yes. That
not a stranger. Not a stranger.
Not a stranger. Only by that cross examination, so there was not to them. There was no cross examination to demolish his case, man. The evidence of PW2, man.
And everybody spontaneously said, few other witnesses, that this man came rushing.
Yes, that corroboration is there.
That is there. And motive is not necessity in case of direct evidence.
Yes,
Though some motive may be there,
once
because
it's-
they have some animosity.
Yes, that is it. In a circumstantial evidence, matter would have been different.
Huh.
It is a case of eyewitness.
Close it.
That's why in the beginning I've already said there's nothing much left for me to argue about.
I thought that it is a case, open and shut case for acquittal.
Even I also thought.
I heard Mr. P. Kotogi, learned counsel for the accused appellant, and Ms. P. Huyan, and senior counsel and additional public prosecutor for the requested by Ms. M. Das, R. Das, comma. There is one M. Das also.
M. Chakraborty.
Oh, Chakraborty.
Got married.
Learned counsel for the respondent state. Arguments are complete. Judgment is it.
No.
We close the
Lordship, got a order sheet dated 30/2022, Y2313. Accused is present, although today is fixed for passing judgment. But while perusing the case record for the purpose of preparation of the judgment, it has come to my notice that every circumstances and incriminating evidence were not put separately to the accused while recording statement under section 313. If those were not put separately to the accused, she will not get opportunity to explain the same, and that may cause prejudice to the accused.
And Mr. Kotogi would have made a case
Yes.
out of it.
Lordship, may I have a look at it?
No, it's okay.
Even for whose bag also, what?
It would have been remanded.
Remanded, but evidence of PWC remains, man.
Still remains. Lordship, one more matter.
No, today.
No, Lordship, some clarification is required.
Which one?
Small order.
Item 60.
Yes, this is a matter relating to remission, my lord. Lordship, on 22/9/2025, Lordship, a communication was issued by Inspector General of Prisons, my lord,
22?
9/2025, which is based on record by the order dated 24/9/2025. The matter came up. Lordship, here some Lordship, some error has been committed, maybe by me, your Lordship, this honorable court will not make any error. Because your Lordship, here in the communication dated is
Let us see first the communication.
আজিটো নিদিব, আজিটো পিছত দিয়ক 22 communication. Lordship, the last line of the communication clause 2, subsequently the proposal will be placed before the state level review board Assam for consideration. But it has been recorded. Maybe I don't recollect, Lordship, whether it was my submission or not. Lordship, but it has been written, it has been ordered that it has already been submitted, but it is not a case, my lord. I have received a communication from jail, this one, IG Prisons of 13/1/2025. As of date, your Lordship, the required document has not been sent by the Lordship, the authorities of Tamil and Madurai, my lord. In order to place before the state level review board of Assam, my lord. Although it was requested on a number of occasions, my lord. আজিখন দিছে? They had to send a proposal, my lord, for early release of convict with all required documents to the undersigned for placing the proposal before the state level review board of Assam. But that hasn't been done as of now. ঘৈণীয়েকো জনাইছে পাছপোৰ্টত আমাৰ লেটেষ্ট হয় ন মাদুৰীৰ পৰা অহা নাই
Then give this office note, there is nothing. From the Madurai
My
Central Prison.
understanding is that it has been sent. But here from this letter, it shows that they have not received.
This is 13 January two thousand
Latest.
25. This is 25 again.
Oh.
Why don't you get any 26 or what?
26 to full
26, perhaps 26. Date written is 13 January 2025. It should have been, I think, 26.
Yes. It was pursuant to the Honorable Court's order at 3-9 and
Oh.
8-12.
Then
Hmm.
Madurai Central Prison was informed by communication dated 21 to 2025. Then they are saying that they have not received any proposal unless
And then there is another one on 22nd of September.
Submission.
that I have seen last
Yes.
time.
Yes.
But the proposal has not been received. Now
Hello.
it is said.
Lordship.
How it originated, this thing regarding remission?
In fact, he had,
Our book is otherwise ready.
ready lodge, 15 and
She made the,
years.
she made the
Because,
statement.
at that time, if, it will
14 years.
15 years, he had completed perhaps in January 16, he had completed 15 years.
And is it transferred from the Kokrajhar jail
He
to
was,
Madurai?
in jail for 6 years, then he was transferred to his hometown Madurai. He is convicted in Madurai Central Jail now. So as it is a case of although it is a case.
So he made submission on 3/9/2025 that he is in custody
Yes,
for
Lordship.
more than 14 years.
14 years.
Then learned PP was asked to obtain instruction from the IG Prisons.
Yes, Magna.
Whether
we
a
received it.
petition for remission has been made in favor of the appellant, who is presently in Madurai Central Jail
Right.
after having been transferred from a jail in Guwahati.
Because
Assam.
the instruction is that they had already
No,
from
it is in fact wrong. Some substantive proposal will be placed before the state.
Yes, it is, the communication
give you-
already submitted before the court.
Formally requested on 5/2. If you read again, two Madurai authorities have been formally requested by this office by letter dated 5/2/2025 and 21/2/2025 to process the remission proposal if eligibility is established as per Assam government OM dated 6/10/2015 and to forward all the required documents as stated in the OM to the IG Prisons subsequently, that is after receipt of proposal. The
Lordship.
proposal will be placed before the
Yes.
state level review board. So Madurai authorities were requested on 5/2 and 21.
Lordship, I've enclosed the copies here,
Ah,
present
I have seen.
set.
So thereafter, nothing has been received.
yes,
It has to be originated from the
yes,
prison authority
from them it has to.
along with all the required documents. There is a office memorandum that you submit, you have to submit these.
No.
What to do? This is as late as 13 January 2026.
Lordship.
Nothing has been received from Madurai.
ঘৈণীয়েকো জনাইছে
Your wife can only initiate proposal.
Lordship.
We cannot direct. We are not here to.
Previously,
We are here to hear the appeal.
Lordship,
If something happens in the remission, it is
in fact,
all right.
otherwise case is ready for final disposal. 15 years, but Thing is that it may goes in both ways. That is why I want to take a chance. I want to take a chance. That is why.
It is up to you, that your wife has to,
Initially, they had initiated, so probably they will.
if you have got a copy, then your wife can
Yes.
communicate with the
Yes.
Madurai Central Jail authorities that where you are not sending the proposal. Right?
So after 4 weeks, Lordship may fix. In the meantime, I will take instruction.
Get an instruction that she should move the Madurai authority on the
Lordship,
basis of this
yes.
letter. Give a copy.
Lordship to her.
I have
Miss
also
Anna?
photocopied it.
Okay. Heard Miss B. Sharma, you are amicus,
Legal aid.
legal aid counsel for the
Right.
accused appellant, and Miss B. Bhuyan, senior counsel and additional public prosecutor, requested by Miss So-and-so M. Das. M. Das, R. Das. R. Das, Learned counsel for the respondent state. Miss Bhuyan, placing a communication bearing number so-and-so dated 13th January 2025, comma, or to have been 13th January 2026. Bracket closed. Bracket, huh? Has submitted that pursuant to communications dated, pursuant to office letters dated, office letters dated 5/2/2025 and 21/2/2025 from the Office of the Inspector General of Prisons, Assam, Guwahati, with a request to forward a proposal for early release of the convict for the purpose of placing the proposal before the state level review board, Assam. No proposal has been received from the Superintendent Central Jail, Madurai, Tamil Nadu, till date. In view of the above instruction, Ms. Sharma, learned legal aid counsel for the accused appellant, has sought listing of the case after 4 weeks in order to obtain further instruction in the matter from the jail authority, from the authorities in so-and-so into Madurai, Tamil Nadu. List the praise law, list the case on
2302.